Hi, good morning. I want to start by saying thank you for making it out so early and in this weather. But I also wanted to thank the association for inviting me and for giving me the opportunity to talk about this topic in the company of such distinguished scholars and practitioners. So the panel is asking whether international humanitarian law and international criminal law are fit for purpose, and I hope that I will be able to tell you a story and maybe we can start a discussion about this. So in her first report on the situation of human rights in the Palestinian territories, UN Special Rapporteur Francesca Albanese concluded that since the onslaught on the Gaza Strip started in October 2023, Israel has used the International Humanitarian Law, or IHL framework, strategically in order to camouflage and legitimize its genocidal actions on the Strip. After enumerating, she did this in her first report on the situation. After enumerating the multiple violations of the laws of war, and after advancing a cogent argument that Israel was committing genocide within the convention's definition, the Genocide Convention, the Special Rapporteur opined in paragraph 55 that a core feature of Israeli conduct has been the intensification of the de-civilization of Palestinians, which is a protected group under the convention. Israel has used international humanitarian law terminology to justify its systematic use of lethal violence against Palestinian civilians as a group and the extensive destruction of life-sustaining infrastructures. That it has done this by deploying international humanitarian law concepts such as human shields and collateral damage, safe zones, evacuations, and medical protection in such a permissive manner as to gut those concepts of their normative content, thereby subverting their protective purpose and ultimately eroding the distinction between civilians and combatants in Israeli actions in Gaza. In paragraph 57, she continues, on the ground, the distortion of international humanitarian law articulated by Israel as a state policy in its official documents has transformed an entire national group and its inhabited space into a destroyable target. This has had devastating effects, costing the lives of tens of thousands of Palestinian civilians and destroying the structural fabric of life in Gaza, thereby causing irreparable harm. The rapporteur states that that this language of international humanitarian law and the linking of civilian concerns to Hamas in the conflict led to the creation of a world without civilians, where everything and everyone became legitimate military target. If one is to agree with the conclusions of this report, then the suggestion really is not just that IHL cannot protect civilians in contexts such as Gaza, I would assume, where there is asymmetrical power balance, but that its mere existence, i.e. the existence of IHL itself, might actually endanger civilians by offering legitimizing language to parties who are intent on annihilating those who are subject to their military control. And the effect is not really exclusive to Gaza. In April 2023, a war broke out in Sudan between two rival forces who are fighting for control of the country and its resources. This war followed on from a fraught period of uneasy transition, which followed on from the December Revolution, and a partnership between civilian forces in the country and both of these warring parties. So at the time, or in the past, both the Rapid Support Forces and the Sudanese Armed Forces have together committed atrocities in the region of Darfur, as has been recently determined by the International Criminal Court in a 2025 decision in the ICC prosecutor versus Ali Muhammad Ali Abdurrahman or Ali Kushayb. In 2003 and 4, where these events were taking place, the events adjudicated by the ICC, the RSF and the Sudanese Armed Forces were on the same side. At the very beginning of the conflict, the RSF mimicked the narrative of Israel in Gaza by highlighting the fact that the armed forces were remnants of the deposed Islamist regime of Umar al-Bashir, and as such are nothing but terrorists. This narrative was used in order to entice Western countries or Western policy to allow the RSF to do as they pleased, given their objective of defeating Islamist others. What the RSF pleased, incidentally, has been described by the UN fact-finding mission as a deliberate strategy of terrorizing and punishing civilians. They also found that the sexual violence they committed was staggering and was neither gender nor ethnic specific. Despite paling in comparison to RSF violence, the Sudanese armed forces have also committed violations of IHL and international human rights law, especially in the beginning of the conflict, with the shelling of entire cities and the targeting of civilians and civilian concerns, also documented by the fact-finding mission. In defense of these actions, a spokesperson for the armed forces intimated that the legitimacy of its actions is comparable to the legitimacy of the US action in Iraq, where collateral damage was acceptable given the military objective in question. So what does this say about international law? I think that the events in Sudan and Gaza are sobering in that they suggest a couple of things. First, that states are not fundamentally interested in human security, as opposed to, say, state security, even though the interest in state security itself is not clear in the situation in Sudan. And secondly, that international law and legal language can be weaponized against civilians, unless, of course, such action is guarded against by other accountability measures, including a free and fair press. The question posed in this panel is whether IHL and international criminal law are fit for purpose. And I think that begs the question of what exactly is the purpose of these bodies of law. And to elucidate what I'm trying to say, and also just to dodge having to talk about IHL, I think I want to focus on international criminal law. So international criminal law, if you ask theorists from maybe before the 1990s, would have been explained as a gap filler, in the sense that in relation to atrocity crimes, the expectation is that these crimes will be addressed within the traditional jurisdiction of domestic courts of a nation state. It's also worth mentioning at this juncture that the primary goals of international criminal law are essentially the preservation of international peace and security and the protection of fundamental human rights. These fundamental human rights and their violations would usually shock the collective conscience of humanity. I don't say this without having looked into it, but perhaps one would remember that the Nuremberg trials, as much as we remember them as ushering in an era of human rights flourishing, were actually focused on the crime of aggression. However, and because of an increasing trend to center suffering, when considering what are highly political conflicts, what happened in relation to international criminal law is that we started to imagine it as an antidote to all the ills of the world, despite its unsuitability by design for that role. So I think that international criminal justice is an unsuitable vehicle to address the kinds of conflict we see in Sudan because of a number of features or assumptions about the system. These assumptions include the idea that there is a clear distinction between victims and villains, that ethnic divisions are a mere construct of political elite who are intent on disregarding the law for their own ends, and that there actually exists a rule of international law that can replace and supplant the legal and political matrix of a rule of law state. And I'm going to use Sudan as an example to explain why these assumptions are inherently flawed. So let me say something a little bit about the dynamics of the current war in Sudan. Perhaps you would guess from my discussion of the fact-finding mission report that I don't think that there are any good guys in this war. As far as the Sudanese people are concerned, the two sides are equally bad and equally deserving of censure. This is not just because we believe that this is a counter-revolutionary war in response to the Sudanese people's demand for a civilian democratic rule as evidenced by the December Revolution, but also because of the behavior of the warring parties on the ground since the start of the conflict in April 2023. So both parties have been accused of violations of IHL, including indiscriminate use of aerial bombardments and targeting of critical civilian infrastructure, including schools, universities, hospitals, and economic institutions. They have also both weaponized humanitarian aid and attacked local aid workers who are the only defense civilians have against starvation and destitution. However, and despite this equality of arms, if you like, in villainy, what we see more of in the media is a focus on the crimes of the RSF because of the group's characteristic brutality, which included wanton looting of property, widespread sexual violence, racialized attacks on civilians, summary executions, and attacks on refugee camps. The tendency to engage with these violations on the basis of suffering alone without additional political contextualization or understanding results in the necessary legitimization of the Sudanese armed forces, despite the role they played in propping up, empowering, and training the RSF to do exactly what they're doing in the conflict right now. So when, for example, we look at the cases brought by the de facto government of Sudan against the UAE at the International Court of Justice concerning violations of the Genocide Convention, we literally have to ask the question, why was the case not brought in relation to the act of aggression in violation of Article 2.4 of the UN Charter instead of under the Genocide Convention? It would have been an easier case to win. However, the objective was the case was not to prevent the commission of genocide and therefore, but to score political points against the RSF. I say this because prior to the breakout of the war in February 2023, both the RSF and the armed forces were conducting recruitment drives in the region of Darfur along ethnic lines, as has been reported by UN bodies. It is inconceivable that the parties were not aware of the effect that this is going to have on the scale of ethnic violence during the war. As such, using the law on genocide to absolve the Sudanese armed forces is both politically naive and ultimately damaging to the prospects of long-term peace and recovery in Sudan. This also leads me to the question of the excessive racialization of conflicts in the country. We often hear that what is happening in Sudan right now is an attempt to finish the genocide which started in 2003, 2004 in Darfur. Yet this is not borne out by the facts on the ground. While the extent of violence in Darfur is disproportionate when compared to other parts of the country, the RSF attacked civilians all over the country and across ethnic lines. To add to this, the 2003 conflict itself was not ethnic in nature, even though it suited both the government of Sudan and the international organizations, such as Save Darfur, to racialize the conflict to the detriment of the people of Darfur. For the Sudanese government, it was important to detract from their political crimes against any form of opposition to their inherently military dictatorship, so oppressive military dictatorship, led by Umar al-Bashir, who started his reign by visiting what I would for now call non-sanctioned violence, subject to further research, against primarily northern Sudanese men, so non-racialized men and women in the capital. As such, the narrative on genocide and the endemic racism in the Sudanese society, or claims of that, diffused the guilt that should have been squarely put on the military dictatorship, and which now instead kind of became the guilt of the entire Sudanese people. What the focus on atrocity crimes did in Sudan in the early 2000s was to actually hijack the conversation away from the Sudanese people, who, when they had the chance to say something about it, in the winter, spring of 2018, 2019, during the uprising, they said, "Ya عنصري ومغرور كل البلد Darfur," i.e., meaning, you racists, we are all Darfur, for which I suppose we have been punished now. The last thing I want to say about the unhealthy assumptions embedded in international criminal justice is this idea that there is some sort of rule of international law that can protect populations in the global south from the predation of their own governments or the governments of those who are oppressing them. But this idea is belied by the actions of the global north anyway. So the European Convention on Human Rights states that the best guarantee for human rights and the freedom on which they depend is an effective political democracy. Furthermore, the idea that international law or the international legal system will work to protect Sudanese citizens from the violence of the RSF ignores the effect of geopolitical interests on the workings of international law institutions. We have seen, for example, how the war in Ukraine has affected the UNSC's ability to make tangible resolutions in relation to Sudan, because Russia kept on vetoing resolutions on ceasefire merely because they were put forward by the UK. To add to this, the war on Gaza revealed not just the fragility of the norms governing global north behavior when it comes to conflicts in the global south, but also the lack of real commitment to human rights and the protection of civilians in these countries. To give evidence of this rather bold claim, I refer you to an article written by Mark Townsend in The Guardian just a couple of months ago, I think 3rd of December, where he reports that the FCDO apparently prevented analysts from warning of a possible genocide in Sudan, presumably in order to protect the UAE. Mind you, the UK is the pen holder at the UNSC when it comes to Sudan. Thank you.